Hi, everybody. Thank you so much for joining us this morning. We are so excited to continue our series, breaking down some of the foster care basics. Today, we get the opportunity to learn more about the family court system, legal operations. We're talking to Robert Cohn. Robert, thank you so much for being with us today. Would you just kind of introduce yourself and tell us about your role at DSS?
Sure. Thank you, Kelly. My name is Robert Cohn. I'm an attorney. My official job title is I am the Assistant Managing Attorney for County Legal Operations for the Office of General Counsel for the Department of Social Services, which is a really long way of saying that I help oversee all of the county legal offices across the state in all 46 counties. I help supervise and train the attorneys that represent us in family court. And before I did that, I was a county attorney. I primarily practiced and handled cases in the Greenwood, Abbeville, and Newberry area. But I now, because I have to go fill in and kind of pinch hit, I try cases all over the state just as needed. So that's, but that's the short version of what we do. I basically work with all of our county attorneys at different, at the various locations around the state. So, and been doing that now. I represented parents at the beginning of my career, and when I was in private practice, and then I went to work for the state. First as a contract attorney, and then about 16 years ago, and then about 11 years ago, I became a full-time employee. So I've been doing this for quite a while.
As a foster parent, we know going in that court and the legal system is going to be a part of foster care. But for so many of us, we just have no real experience or understanding of what that court system is going to be like. And what are the different hearings? Who are the different players? So can you just give us like a really basic understanding of the county attorney? What is their role in a foster care case?
Sure. The county attorney, and for foster care, I'll kind of give as a kind of a quick overview of that process y'all familiar with. Child is brought into foster care either by law enforcement or court order. There has to be, when that happens, the child is, a foster home is located and they're placed, and a court action, a legal action has to be filed in the family court in that county. And that action is filed by the county attorney. And at that point, usually it's pretty early in the case because we're just finding out what happened. It's done on an emergency basis. But the county attorney's job is, first of all, is to draft up what we call a complaint, which is just sort of outlining, well, here's the facts as we know it, for why this child's been brought into foster care, and we want the court to grant DSS custody while we continue our investigation, and then determine if there was abuse and neglect, and if so, what kind of treatment services should be ordered. So you have probable cause hearing that's got to be held within 72 hours. When the child comes in, the attorney has 24 hours to file an actual legal action. So there's a lot of scramble activity right at the beginning to figure out what's going on, and names and addresses and who are the parents and that kind of stuff. Then you have to have a probable cause hearing before a judge in 72 hours. That's a very short hearing that usually is just about 15 minutes. And it basically just the law enforcement officer or whoever testifies to say, this is why we took the child into custody. The DSS attorney presents that case, but it's very short. They basically it's very simple. Here's what we found. Here's what we saw. This is why we took the child into care. It's not a full trial. The defendants aren't allowed to ask questions. They may or may not have an attorney at that point. Most of the time they don't. That's usually the first time they get a chance to apply for one or ask for one. So that's, again, pretty quick. It's just to say, okay, this was justified. And then the next hearing in the process is what we call a merits hearing. And you may hear the term first call merits hearing sometimes. And the reason we say that is under the statute, you're supposed to have a merits hearing within 35 days. And then the court can extend it, can continue it for another 30 days. But it's, under the statute, you're supposed to have completed that merits hearing in that period of time. And that means that, the purpose of a merits hearing is to present evidence and testimony and witnesses. Was the child abused or neglected? The court has to make that determination. If so, what sort of treatment services are needed, to try to address the problem or solve the problem and get the children back home. And third, while that is going on, who should have custody of the child? Is it going to be DSS and the child staying in foster care? Have we identified a relative maybe that could take custody while the parents work treatment and so forth? So, I mean, so the DSS attorney's role early on is to put that case together. What witnesses do we need to call? What documents do we need? Do we need drug screen results? If the children were physically or sexually abused, we usually have them get what we call a forensic interview. Has that been done? If so, do we have a copy of the interview? Do we have the report of did they have a medical exam? The doctors, there are their medical records that show, what kind of abuse was taking place or that they weren't getting necessary medical care, school records. The attorney working with the caseworker assembles all that together because their job is to present that information to the court and say, okay, Judge, here's what we found. Here's what our investigations determined. This is what, and then this is what we're recommending should happen as a result of that. So the attorney spends a good bit of that time reviewing all those records, talking to caseworkers, interviewing witnesses, potentially talking to you before the trial. But as a practical matter, what happens is usually you have a first call merits hearing that within that first 35 days, we may or may not have our act together and have our investigation completed at that point, because a lot of times we're still waiting, like on those forensic interviews. It can take a while to get them set up. We're waiting on records from the school or so forth. So sometimes we go to those hearings and we say, well, we haven't finished our investigation. Or even if we have, the parents, if we go to that first hearing, we set for 15 minutes and we talk to the parents and the other participants and say, okay, here's what we're recommending. Here's the finding we want to ask for. Here's the treatment we're recommending. And this is where we think this is the custody arrangement we think we should do. If the parents agree to that at that point, then we can turn that into a written court order and we proceed from there. If they don't agree with it, and whether they have attorneys or ask for attorneys, that they may or may not have them at that point, but they can request legal counsel and then they can have a trial. Then that usually when you start seeing what we start calling setting subsequent merits hearings. And again, part of what to figure out once everybody has an attorney, if they're going to have that, well, how much time do we need? So part of the DSS attorney's job is, okay, because most of our kind of normal standing docket days we have, like Greenwood, for example, has a half day a month. Well, there may be 15 cases scheduled for that day. You're not going to have a trial on that day. You're going to go in, or if you do, it's going to be just a really short hearing to say like an update or whatever, what's going on. So we have to find time on what we call the private docket. That's just the days of the week that the court hears other kinds of cases like divorces or things like that. So we have to find time for that. And of course, the whole system is backed up. So that's why you'll say, well, wait a minute, we're supposed to have it in 65 days, and it's been 8 months. I said, yeah, it's because there's an 8-month back, and the more court time you need, I mean, the attorneys can get together. If we have a really bad sex abuse case or something like that, where there's going to be a lot of witnesses, medical witnesses and so forth, we say, well, we need 5 days for a trial. Well, that's an extraordinarily long trial in the family court system. And right now, if I were to walk into if I were to go to the administrative judge for Greenwood County and say I need 5 days, he's going to probably tell me September, October, something like that, because they have hearings scheduled all the way that far. So that's one of the things that's part of what the attorney is doing. DSS attorney is also kind of to assess, okay, what do we need to prove our case? What witnesses do we really need to call? How much time is that going to take? We got to look at, how many parties are there. If we get one where we got, 5 kids and there's 3 dads and a mom and some grandparents mixed in, those are just going to take longer, even if it's only a few witnesses, because everybody gets a chance to question the witnesses. Everybody gets a chance to call witnesses. So we have to, a big part of what the DSS attorney is doing is kind of assessing the case, deciding what needs to be, what do we need to prove our case? How do we do that in the most efficient way possible while still giving everybody their due process and their right to present it? So, and then I can keep talking about I don't know how much more you want to talk about the process and keep going, but after that merits hearing, there's then various hearings down the road, judicial review or permanency planning, which are basically just review hearings where we update the court. How's everybody doing? Parents, are they finishing treatment, not finishing treatment? What's the agency's plan? It's been a year, where are we going? And the DSS attorney obviously continues those follow-ups that whole time and presents that information as it comes up.
So, because I know that foster parents have this question because they care about these kids, they care about these families, as does everyone involved, of course. And you mentioned the backlog. Are you able to tell us if a case just isn't moving forward in the amount of time that a foster parent thinks that it should, what can they do? What can they do to advocate, knowing that there is this immense backlog because of COVID and courts being closed and now reopening?
My recommendation, because the expectation we have for our attorneys is that there's always a court date scheduled. Okay. I mean, it may not be when we want it to be, but if we're saying, well, we need to have a hearing for this, we need to have a merits hearing on this case. Okay. When's it going to be? Get a date.
Mm-hmm.
And yeah, we're not supposed to walk out of hearings and say, well, we'll schedule it and get back to you. No, it's supposed to be specific.
Mm-hmm.
Occasionally we run into the problem, like if it's too far out, just as a practical matter, judges are kind of the courts are scheduled on 6-month intervals. So like January through June, and then July through December. And the Supreme Court, the court administration that assigns judges to hear cases, they don't put out the list of what judges are going to be holding court where, except twice a year. And so like right now we're kind of waiting for when, what weeks are we going to have court from July through December in the
Mm-hmm.
various counties and circuits. So that creates a little bit of a problem, because how do we schedule it? Some counties, if they're big enough, they have court every week. They know, okay, well, we have court, we'll put that on the third Thursday in November, because because we have court every Thursday. But if you're kind of like Greenwood, we don't know when court's going to be in
Yeah.
October or November, because we haven't gotten the schedule yet. So that's also one of the attorney's duties, is to say, okay, make sure once you get that schedule, are you actually going in and putting in court dates for that? But as far as what foster parents can do, a lot of it is, first of all, ask regularly, say, hey, have you got a court date yet? Do you have a court date? And if the caseworker says, I don't know, I said, well, can I ask the attorney? You can. You can reach out and say, I'm just curious, or at least, start with the caseworker. If the caseworker says I don't know or doesn't get back to you, I mean, it's fair to ask the attorney. The guardian ad litem sometimes knows, but they have this, I mean, they're kind of waiting on us usually to get that information for them. So, I would say if you're trying to advocate, I mean, now I won't lie. If you come to me right now and say, when's my hearing going to be in November? I'm going to tell you, I don't know, because I don't have the schedule yet, but it's fair to ask the question.
So the foster parent, wants to know when court's going to be, or they have a question for the attorney. How do they find out who their attorney is and how to get a hold of them?
Well, obviously, of course, you can always ask your caseworker. That's one way to do it. But there is also, and I can copy the link into your chat box in a minute, but there is on the DSS state website. If you go to the homepage, there's a link, there's a button that says about. And if you click on that about, and then you scroll down, that says legal team. And if you click on that link to legal team, on that page that comes up, there is a directory of DSS attorneys for each county. It identifies for each county who is the managing attorney. Now, there are more than, a lot of those counties have more than one attorney, but that will be the attorney who runs that particular county. It has their phone number, it has their email address. I will go ahead and tell you now, I wouldn't bother calling them. I'd send them an email, because you're going to much more likely to get a faster response from an email than you will from a phone call. We're in and out of court. I mean, I do return phone calls, but it's a lot easier and faster for me to respond to an email. And also it'd be partly also because we have to know who we're talking to. When a
Right.
foster parent emails us, we have to be sure it's you are who you say are. So if you email us, then that gives us time to check with the caseworker. Is this really the foster parent? Because the other thing you need to realize, the attorney, we don't always know who the foster parent
Mhm.
is. We a lot of times find out at court or shortly before court, oh, they're in this such foster home, because kids move placements. They'll be at one home when the case starts, and then 3-5 months down the road, oh yeah, they're moved there now with Kelly Lindquist and her husband,
Mhm.
and her
Yeah.
family. Okay, that's fine. But again, we're not notified every time a child's placement changes. We basically find out shortly before the next hearing. when we're getting ready to go back into court. So we have to, when you send something, we are going to have to check and make sure it's information you're entitled to, and this is not somebody's grandma just being nosy.
So, what interaction, if any, should a foster parent expect with an attorney? I know that we've had a number of children, a number of cases, and we have had no interaction with an attorney. Maybe we've met the attorney or seen the attorney in court, or maybe we have had some interaction. So it really, for me, in my personal experience, has varied. What kind of interaction or communication should a foster parent expect from the attorney prior to court, during court, after court?
Prior to court, the main the primary interaction you would get, if any, is you should be getting a notice of the hearing. You should get a letter or notice, saying, okay, hey, there's court on this day at this time. You're free to appear, and you can make a statement to the court if you want to. That's a standard form that we send out every time we notice a hearing. You should be getting those. If you're not, and you're just finding out about court because your caseworker tells you about it, that's actually an issue that needs to be taken up with the attorney, because the legal office is supposed to be making sure that's sent out to foster parent. Sometimes we send it to the wrong foster parent because we weren't told it changed, but sometimes it's just forgotten. But that's one thing you should get, is at least at a minimum, you're supposed to get a notice of the hearing. Other than that, prior to court, the only times you usually see us contacting foster parents, it's usually going to be after their merits hearings, after there's already been that finding and we're now at the review stage, or got a review hearing or a permanency planning hearing. An attorney may need to talk with you because something may have happened while the child's been in your care that we may want you to testify about it. Maybe you heard something during a visit, or you observed how the child is with their parent, or how the child behaved after they come back from a visit, or just how they're doing in your home, mental health things. Yeah. A lot of stuff like that. So sometimes we get a lot of that information from the caseworkers and from the guardian and from other therapists and people who are involved with the child. But sometimes we like to get it from the foster parent, and in particular if it's something that you saw or heard, like the parent do at a visit. Well, we need you to testify about that because it has to be the person who actually witnessed it or heard it. So, but that's not in every case. I mean, I would say that's that's unusual. I didn't in my whole time, I only rarely have contact with a foster parent before court unless they initiate it because they have a question. Now during court, when you go to court, you should have, they should at least be recognizing you, say, oh, foster parents are here, would like the opportunity to address the court, and identify you, and then the judge will give you that opportunity at the appropriate time during the hearing. I always encourage foster parents to say, now make sure your caseworker knows that you're there, and make sure that the caseworker tells the attorney that you're there, because if you've been to court, it gets kind of crazy. There's a ton of people up there and all kinds of folks running around, and the lawyers, talking to a bunch of different attorneys and guardians, and we're negotiating. The attorney is going to be there. You're going to see them kind of in and out, running around. And most of the time what that is they're either negotiating to see if they can settle a case or resolve a case, or they're just trying to get with the judge to figure out, okay, who's here? Can we take the next case in? Which one do we call, depending on how things are scheduled. A lot of times we just have sort of a cattle call where everybody's there at 2:00 for the hearing. And so, okay, well, is everybody here on the Smith hearing? Is everybody here for the Jones here? And we're getting the caseworkers all in. So it gets very confusing very quickly. And I've had that situation. I try to remember to ask my caseworker or my paralegal, say, hey, is the foster parent here? But again, we wouldn't know what you look like unless we just happen to have worked with you before in another case or something like that. So just bear in mind, it's important for you to make sure we know you're there. But that's the time. Again, at that point, we may talk to you. We may have something to discuss about that. But certainly, if you want to address the court, it's important to try to get that word to the attorney so they remember it. So that they make sure that you're given that opportunity, because you have that right. But I can tell you, in the hustle and bustle of a court time, I've seen it. I've done it. I've forgotten, until somebody elbows me and says, hey, Robert, the foster parent wants to talk. Oh, I'm sorry. I mean, it happens. And then as far as after court, would be rare, unless there was something I've had to do it where like we had something ordered at a hearing, and then I get a complaint from the defense attorney, the foster parent's not allowing my client to do this or something like that. And I have occasionally reached out along with the caseworker to the foster parent to find out what was going on, but that's very rare. I don't think I've done that but a handful of times in the last 15 years, but it can be. So does that answer your question? I mean, it's not a huge amount of
Yeah.
interaction. Most of the time, your caseworker is going to be your main point of contact with
And I
DSS.
think it's just helpful to know I I shouldn't expect to hear from the attorney.
Right.
Just having that expectation, but it's possible that I will have that interaction. So,
Possible. And
you
certainly,
know,
if you have a question, feel free to contact us. I mean, again, don't let yourself be confused if what the caseworker is telling you doesn't make sense. It's okay to ask the attorney because sometimes the caseworker misunderstands the next
right.
step or
And I
whatever.
think that's the whole reason that we're doing this series is it's so easy for us to misunderstand or just not know what we don't know in terms of what are the roles that everyone's playing.
Sure.
So one of the things that we like to do as well is try to understand a little bit better. What are some of the challenges that your team faces? What are some of the challenges? You mentioned these large caseloads, the amount of work that goes into preparing for a case. But what are some of the challenges that attorneys may face in presenting a case?
Well, I mean, like I said, I mean, we have the same problem every other part of the child welfare system. Too many cases, not enough time, not enough manpower. We're all of our agents, all of our legal offices are pretty much understaffed. This American Bar Association says, the appropriate kind of caseload to attorney ratio for child welfare cases is about 65 cases per attorney. Almost all of ours are carrying more than 100, at a time,
Wow.
some as many as 150 at times, particularly when we're shorthanded. Um, so, I mean, that's just a resource thing. And right now recruitment is tough. We're having a hard time, just the job market kind of overall, it's hard to get recruit people to come work for us. We got about 30% of our attorney positions right now are vacant. And so that, makes it difficult to move things along. Obviously, time, just resources again, judges and courtroom time and so forth. I mean, just trying to balance and trying to understand, okay, how do we prioritize? We've got all these different kids in foster care. How do we prioritize which ones need to go first? How do we assign court time when how do we allocate that out? And then we still have cases involving children that aren't in foster care that have been, some of which have been lingering around for years and need some kind of resolution because those families need that help too. So that's a big challenge, is trying to what we call docket management, is figure out how do we make best use of our time, not waste people's time, but also have our cases prepared the way they need to. Ongoing struggle is getting the information we need. From, we have a lot of turnover among our caseworkers. I'm sure y'all have found, you see that too, that you deal with different caseworkers. It's because people leave. Well, that creates problems for us too, because the caseworker who knew what was going on has now left. And now the current caseworker, you're in the situation where you know more about their case than they do because you've worked on it longer. We have to help them get up to speed so they can, because they can't answer the questions that need to be answered at a certain point, or we have to track down witnesses. And obviously the challenges when folks do have, when they get attorneys, representing them. I mean, that's their right. And I actually generally encourage people to get attorneys because attorneys understand the process and can then explain that better to their clients than if I'm just talking to, a person off the street who's got their legal training from, watching television. They don't understand the process as well. So, but then, I mean, got to deal with those attorneys. You got to get them the information they want, and in a timely manner, and trying to keep their needs met and your
Mhm.
client's needs and keep up with all that. I mean, it's the again, if we had smaller caseloads, it wouldn't be that difficult or that complicated. But the more, unfortunately, the busier we are, the harder it is to do what I would call quality legal work. And so you end up being forced to improvise more than I know I would like to. When I would, when I was in private practice and would try like a divorce case, I mean, I'd have months to prepare for that hearing. DSS, I might have hours, and certainly, only a week or so. and to deal with some pretty dramatic, and difficult issues. And of course, the SS attorneys deal with some of the same trauma. I mean, we're having to read and watch forensic interviews of these children who've gone through this horrible physical and sexual abuse, and it's tough on a lot of people just can't stick with it because it is so demanding. I mean, you guys, I know, hear these same stories that we hear. I mean, it's awful, and it can wear you down. So those are some of the struggles. I mean, there are others, but I think those are just some of the things that we deal with as far as the resources and turnover and things like that are kind of a never ending issue that we're constantly having to adapt to.
Well, thank you so much, Robert, for your time today. And thank you for the work that you do and that your team does. I know that the attorneys and the legal team don't get as much thank yous and gratitude as they should. So thank you. As we just kind of quickly wrap up, is there anything else that you'd like to share with foster parents? Maybe some advice or just kind of closing thoughts?
I would just say, for foster parents, don't be, I understand the legal process is intimidating, and a lot of times, and unfortunately, going to court is a lot of time is the toughest time to get. Is when you want the information most, but is the hardest time to get it because there's so much going on and so much activity. So, if you're confused or if you're concerned or you're not sure what's going on, I mean, reach out, to the county, and you don't feel like your caseworker is giving you the information you need or doesn't seem to know, email the county attorney and say, hey, I just don't understand what's going on. We generally are, we want to be helpful and we want to try and educate you. I mean, there's a few limits to what we can talk about, to foster parents versus, other participants in the system, but you're entitled to know, some of the information that's going on about the case and about the children in your care. So, particularly, I know some of y'all, may end up adopting those children. So, I mean, you need to know what's going on, and don't be intimidated. So intimidated. So I can't talk to the attorney. Yeah, you can. I mean, we're human, and we're busy. So I mean, just like it's the way I think of it is, well, if you have a medical issue and you call your doctor's office, how often do you get to talk to your doctor right away? Sometimes you have to wait. Sometimes you have to leave a message and they'll call you back. We're in a little bit of the same boat. I mean, we will get back to you, or we will get somebody to get back to you to answer your question, but it just may not be right then. And I did stick the link to the attorney directory in the chat box for those of y'all that can see it.
Thank you so much. Well, thank you, Robert, and thank you everybody for joining us, and we'll see you next week. Bye.
Thanks a lot. Y'all take care.